If you've been arrested for a DUI in Illinois, one of the first questions you're probably asking is, do I actually need a lawyer or can I handle this myself? The truth is, you don't legally need one, but that decision can have a major impact on your license, your record, and even your future. In this video, we will break down when you might try to handle a DUI on your own, what you're risking if you do, and how an experienced DUI attorney can make a difference in the outcome of your case. If you're facing a DUI right now, don't guess your way through it. Call 618-213-2312 or visit DillonBorriLaw.com. Why hire a DUI attorney? Like we said, a DUI in Illinois isn't just a ticket, it's a criminal case that can affect your license and your record, but most importantly, it can have a serious impact on your future. Even a first offense can have serious consequences, such as heavy fines, potential jail time, impacts on future employment opportunities, etc. So ask yourself, is it really worth gambling your future by trying to handle this on your own? An experienced DUI attorney knows how to analyze the stop, the testing, and the evidence, and identify weaknesses most people would miss. The goal isn't just to handle the case, it's to protect your license, reduce penalties, and avoid lasting damage to your future. Do I really need a lawyer for a DUI in Illinois? Legally, no. You're allowed to handle a DUI case on your own. But what most people don't realize is that a DUI isn't just one process. It involves multiple moving parts, including your court case and your driving privileges, which are handled separately. An attorney's role is to step in and spot issues you may not even know to look for and make sure you're not making decisions that could hurt you long-term. In more complex situations, like higher test results, prior offenses, or accidents, having someone who understands how to navigate those details can make a meaningful difference in how the case plays out. What is at stake in a DUI case? Understanding what is at stake in that file is critical before you decide how to respond to the charges or any early plea offers. In a DUI case, what is at stake can include your driving privileges. License suspension or revocation can affect your ability to work, care for family, and meet basic daily obligations. Hefty fines and court costs. A DUI can bring substantial fines, surcharges, and fees that add up quickly on top of any legal expenses. Your criminal record. A DUI conviction can leave a lasting mark on your record that affects background checks for jobs, housing, and professional licenses. Jail or probation conditions. Depending on the facts and prior history, you may face jail time, strict probation terms, or intensive supervision. Employment and professional licensing. Some employers and licensing boards treat DUI convictions as serious issues, especially in jobs that involve driving, safety, or public trust. Insurance and financial impact. Car insurance premiums often increase significantly after a DUI, compounding the long-term financial burden. Eligibility for diversion or alternative programs. In some cases, access to a diversion program, court supervision, or treatment-based resolutions may limit the damage, but these options depend on how the case is handled. Each of these areas can be affected by how the evidence is challenged and how the case is resolved in court and with the Secretary of State. When self-representation is especially risky. Self-representation in a DUI case becomes especially risky when the stakes go beyond a fine and a short suspension. Complex evidence, such as high blood test results, accident reconstruction, or disputed field sobriety tests, is difficult to challenge effectively without legal training. In these situations, the legal issues are often too technical for a non-lawyer to handle while still protecting every opportunity for a favorable outcome. Self-representation is especially risky if you have prior DUI convictions or other serious traffic or criminal history. The case involves an accident, injuries, or allegations of reckless driving. Your blood alcohol content is very high, or drugs are alleged, increasing potential penalties. You hold a commercial driver's license or work in a field where driving or a clean record is critical. There are immigration, professional licensing, or security clearance concerns tied to a conviction. The prosecution is alleging felony DUI or other serious charges in addition to the DUI itself. In any of these circumstances, hiring an attorney who regularly handles DUI cases gives you a better chance to identify defenses, manage risks, and pursue a more favorable outcome. Even a single consultation can clarify whether representing yourself would expose you to consequences you did not anticipate. When not to hire a DUI attorney. Some people choose not to hire a private DUI attorney when the case is a first-time DUI with no injuries, no accident, and no other aggravating factors, and they are comfortable accepting the standard penalties. If the evidence is very strong, you plan to plead guilty or no contest, and the prosecution is offering the usual first DUI disposition, hiring a lawyer may not significantly change the outcome in terms of fines, classes, or short suspension periods. In relatively simple cases with no prior convictions, no high blood alcohol result, and no allegation of reckless behavior or child passengers, some defendants decide the cost of private counsel is not justified. When the prosecution's case is straightforward and there is little realistic chance of a reduction or dismissal, it can be reasonable for some people to proceed without paying for private representation, especially if a public defender is available. Very limited budgets, clear evidence, and low-risk fact patterns are the situations where going without a private lawyer is most commonly considered. Even in these scenarios, it is still a good idea to take advantage of a consultation to make sure you understand your options before deciding not to hire a DUI attorney. Benefits of hiring a DUI lawyer. Hiring a DUI lawyer gives you someone who knows how these cases actually work, not just in theory, but in your local courts. You also get someone to handle the process for you, explaining your options, managing deadlines, and dealing directly with prosecutors. At the end of the day, it's about having someone in your corner whose job is to protect your outcome, not just process your case. Benefits of hiring an experienced DUI lawyer include targeted review of the stop and testing, identifying problems with reasonable suspicion, probable cause, field sobriety tests, or blood and breath testing that could weaken the state's case. Guidance through the legal process, explaining hearings, motions, plea options, and trial in clear terms so you know what to expect at each stage. Protection of license interests, handling summary suspension challenges and advising on driving relief options instead of leaving your driving status to chance. Stronger negotiation position, using identified legal issues and your personal history to seek reduced charges, supervision, or other favorable resolutions where possible. Attention to collateral consequences, considering employment, professional licensing, immigration, and insurance issues when advising you on how to resolve the case. Consistent communication and advocacy. Having your own lawyer who responds to questions, prepares you for court, and speaks for you before the judge and prosecutor. A lawyer who focuses on DUI defense can help you weigh short-term options against long-term impact, instead of making decisions based only on the next hearing. For many people, the cost of hiring a DUI lawyer is offset by the value of informed decisions and a defense strategy built around their specific facts and risks. How a DUI lawyer can change the outcome. A DUI lawyer can shift your case from something you're reacting to into something you're strategically managing. Instead of rushing into a guilty plea, an attorney can look for ways to improve the outcome. In many cases, the difference isn't just convenience, it's a better result that protects your future. Ways a DUI lawyer can change the outcome of your case include getting key evidence suppressed if the stop, arrest, or testing violated legal standards, which can weaken or collapse the prosecution's case. Negotiating for reduced charges, such as an amendment to a lesser offense, when the evidence and your history justify a more lenient approach. Arguing for court supervision or other non-conviction outcomes in eligible first offense cases to avoid a formal DUI conviction on your record. Presenting mitigation about your work, family responsibilities, and treatment efforts to reduce jail exposure, fines, or other conditions. Advising you when a guilty plea might still be the best option, but only after using every reasonable legal and factual argument to improve the terms. Contact the law office of Dillon Borri LLC for a free DUI consultation. DUI charges move quickly, and the decisions you make early in the case can shape your record, your license, and your options for years. Having a focused DUI defense strategy can make a real difference in how this case affects your life. Contact the law office of Dillon Borri LLC for a free DUI consultation to talk through what happened, review your paperwork, and get clear, realistic advice about next steps. Call our firm at 618-213-2312 or submit an online form at dillonborolaw.com, and an attorney will follow up to schedule your free case evaluation and begin assessing how to protect your record, your driving privileges, and your future.